Hello, Southwest viewers. Disputes between state government and governors are nothing new in Indian politics. This issue has been around since the 1960s. That's why a prominent Dravidian leader and former Chief Minister C.N. Annadurai famously asked, why does goat need beard? Why does nation need governor? Following him, when M. Karnataka became a Chief Minister of Tamil Nadu, he set up the Rajmanar Committee to study relationship between state and center. Now, carrying forward that legacy, Tamil Nadu Chief Minister M.K. Stalin has made debate a national talking point. To discuss this matter, to more know about this, we are joining today with P. Wilson, senior advocate, DMK MP, and legal pillar of DMK in many battles. Welcome, sir.
Welcome.
Sir, first of all, congratulations on your victory.
Thank you.
And before diving into the details, how does it feel, sir? You were right there in the moment when Supreme Court delivering the landmark verdict on this case. This is very important not only for Tamil Nadu but for all over India. So, have you ever experienced the same feeling in any other cases? What are you feeling on that right moment?
We stand vindicated. This judgment is a path-breaking judgment and it's a landmark judgment which have clearly brought victory not only for my leader, Mr. M.K. Stalin, for the people of Tamil Nadu, but whole of India. So, the Constitutional Court has rightly and correctly at appropriate time has risen up and said, look, the will of the people should prevail. And therefore, democracy is for the people, by the people and for the people. So therefore, when the people elect their elected representatives and send them to the legislative assembly or to the parliament, and when the bill is enacted and legislated by the assembly, and when it is sent for the assent of the governor should necessarily and mandatorily follow the constitutional provisions and with the aid and advice of the Council of Ministers and has to grant assents. So that is what this judgment has given a clear mandate to all the governors in India.
Sir, the nation is talking about the case and verdict now. Could you briefly explain what the Supreme Court says, especially the time frame set by Supreme Court for the governor's decision?
The Supreme Court has clearly interpreted Article 200 and what are the options that is available to a governor when a bill is enacted and sent for his assent for the first time or for the second time. Article 200, which according to the Supreme Court and which the Constitution also says so, has given three options to a governor. Whenever a bill is enacted and sent for the assent of the governor, A, the governor has to approve it, B, the governor can withhold that approval, C, the governor can send it to the president. So this three option is available at the first instance. So if the governor withholds the bill and returns back it to the legislative assembly, then once the legislative assembly reenacts it and send it back to the governor for the second time, then all his options are closed. The only option is that he has to grant assent. So therefore, the interpretation of the constitutional provision by the Supreme Court is that only in a case where the governor feels that the bill has to be assented in 5 situations, that also the Supreme Court has clearly said what are all the relevant provisions where the president has to assent. So in those situations alone, the governor can reserve the bill for the consideration of the president. So therefore, this is a landmark judgment which clearly acts as a guardrail and acts as a guide for the governors for the days to come that all governors who are thinking that they have sky-high powers and they can act do independently as they like, can take the law into their hands. All that is now put to rest, and this is a complete encyclopedia for so far as Article 200 is concerned.
Okay. So one of the 10 bills involved is Chief Minister making Chief Minister the Chancellor of a university. So now that Supreme Court has upheld it, does it mean Chief Minister MK Stalin will officially become the Chancellor?
To my knowledge, all the 10 bills are relating to the boosting out the governor from the selection process of the Vice Chancellor. The governor is stripped of the power from the selection of the Vice Chancellor, and not for removal from the post of the Chancellor. So the governor still continues to be the Chancellor. Only the powers of the governor as a Chancellor in the selection of the Vice Chancellor, including the inspection and inquiry and other things, have been completely taken away. So therefore, governor still continues as a Chancellor.
Is there any plan to move that case in SC to remove governor as Chancellor, sir?
That only the assembly has to do it, because the statute clearly says that the chancellor can be the governor only. So therefore, for that, so far as the cases which or the statute which is covered under this decision, or the universities where we have dealt with, in those universities, the chancellor is only the governor. So therefore, if the legislature wants to remove the governor to be as a chancellor and have the chief minister as a chancellor, well, it is well within the powers of the legislature to bring in necessary amendments.
Okay. So within the constitutional framework, if a state government passes a bill twice and send it to governor or president, it should be approved formally. Normally, they should be approved the bill. So this, since Supreme Court has approved all these 10 bills, will it be this principle also apply to NEET exemption bill that Tamil Nadu already passed twice and sent it to governor now, and the president also rejected the bill? Can you use this judgment to push that case to in SC?
So far as the NEET is concerned, that stands on a different footing. The NEET, is a subject matter of a concurrent list. So therefore, the state has legislated exemption bill and it has forwarded to the governor with the recommendation that it has to be sent to the president. But what the governor has done at the first instance is he has unnecessarily raised certain questions and asked for certain clarification, which is not within his power to do such things. Constitution doesn't permit him to act like a judicial body, asking the legislature how you can legislate a law. So that was the way he did at the first instance. So therefore, even otherwise, the assembly sat again and it has sent back the bill to the governor, and he has forwarded to the president. Now, what happened in this case is there are on 8 occasions. It appears that the union government has been asking certain clarifications one after another to the state government, and the state government has given a clarification. And after that, on the aid and advice of the union council ministers, the honorable president, has withheld the assent. So therefore, that NEET issue stands differently from the case which we have dealt in this judgment.
Do you think the clarification requested by union government is unnecessary? If so, what are the clarifications they are asking?
The clarification, you can't say it is unnecessary. It is a clarification which they wanted to know well within their bounds, and that clarification has already been given by the state government.
Okay. So in Tamil Nadu, governors have always been a controversial question. So during Anna's time, Kalaiñar Karunanidhi's time, and now MK Stalin's time. So within the constitutional amendment to Is it possible to bring a constitutional amendment to completely remove the governor from the governor's post? Has the DMK ever thought about this initiative?
The constitution can be amended by the parliament, and there is no second thought about amending these provisions which are relating to the governor. You require the ratification from the state legislature. So therefore, the parliament is well within the power to amend so far as the post of the governor, and even to divest the powers to the speaker of the assembly, state assembly. So it is not difficult for the parliament. If there is a will of the government, that can be done. Now, after seeing the way the governors are behaving and conducting themselves, particularly in non-BJP ruled states, it is high time that we have to think whether the office of the governor at all is required. Because this institution of the governor not only brings a financial burden to the states, but also disrepute to the states, and the states are spending a lot of time in the courts to fight against the governor for unwarranted issues, where the governor himself can do it, but wantonly the state is dragged to the courts. The state has to wander in the courts for the getting orders in its favor, and ultimately, the governors are the reason for so much of money being spent on litigations, expenses incurred, and the time being spent by the state in these legal issues.
This governor issue, not only in Tamil Nadu, as you said, it's in Kerala, it's in West Bengal, all over non-BJP states. So you are also MP. So when MPs in the parliament pushing something in the parliament, it can happen. So is there any plan for DMK or India Alliance MPs to push this matter on the parliament?
No, time and again, the debate about the governor's functioning has been brought before the parliament. Even last sitting in Rajya Sabha, there was a special motion moved by a Kerala MP, and it was debated. So therefore, this is receiving the attention of the union government, that the post of the governor are now being misused, and they act like as an agent of the union government. So certainly the MPs are also aware that the post of the governor is only a liability, and it is really not giving any good, doing good things to the state.
So unlike other governors in the state Tamil Nadu history, as DMK claims, aren't Ravi intervening in day-to-day activities of government functioning? If so, why not ask for his recall from union government?
That the DMK has already, sought for his recall. I still remember Mr. T.R. Balu himself has spoken about this. So that is always there. And it's a union government right from the beginning has been protecting the governor, not only Mr. R.N. Ravi, but there are governors in West Bengal, in Karnataka, as you said, in Kerala, Telangana also we had this, Punjab also we had that governor, Delhi is also there. So time has come where the post of a governor is at all required under the constitution. The union has to think.
So Tamil Nadu secured a landmark verdict in this case. So who is the highest authority? Can the union government remove, or the president cancel the Supreme Court's verdict?
No, there is a separation of powers. There is no question of the judgment being nullified. No one has got power to cancel it. Even the legislature has no power to cancel it. So therefore, I don't think so. Anything can be done. When there is a judgment, it's a law of land. The Supreme Court judgment has to be respected. It's a law of land.
So recently, the DMK challenged a new Waqf board bill in the Supreme Court after it amended in the amended by Union government. So it looks like DMK is raising its voice on national issues against BJP's actions and legally taking on the BJP in many matters. Can we say MK Stalin is slowly becoming a national leader after Kalangya? What's your view?
In my view, our beloved leader, Mr. M.K. Stalin, has all the qualities and a qualification now to become a prime minister of this country. Every issue which he takes up, it's a national issue. And delimitation is also a national issue. A case where from 1976 onwards, you have not given effect to the current population census and brought a delimitation. Therefore, when from 1976 you have freezed the delimitation of constituencies, that too on the basis of 1971 census, there is no, therefore, without a proper, clear vision as to how the union is going to proceed, the states which has followed, which has blindly accepted the family planning formula and has implemented the family planning scheme in the states, reduced the population, they should not be deprived with a number of constituencies. That is why our leader has correctly raised up this has raised this issue, even though the impending danger is in 2026. So, be it delimitation, be it the language issue, and even for the rights of the states, our leader has been a crusader, a warrior, a front runner for all the rights of a state that is available under the constitution. So, in my personal opinion, I feel that he has got all the qualities to be as a prime minister of this country.
On the delimitation issue, Union government calling it as just a fear-mongering thing that DMK is trying to hide their failures within the delimitation request. So you also, our Chief Minister M.K. Stalin also formed a joint action committee. What are the committees doing currently, and what is your action plan to counter this delimitation thing? And could you briefly explain what will be the threat to us, our southern states?
I have already told you that from 1976 onwards, the state which implemented the family planning scheme, they had less population. The state which violated the family planning and did not adhere to had more of population. So therefore, the union, when Indira Gandhi, she was prime minister, she took the stock of the growing population in the states which violated the family planning and the state which followed the family planning. Therefore, she didn't want to deprive states like Tamil Nadu, Kerala, Karnataka, Punjab with less number of population. Thereby, the constituencies gets reduced. So therefore, in 1976, they introduced a 42nd constitutional amendment, which freezed the delimitation on the basis of 1971 census. After nearly 30 years, in 2001, during Vajpayee government, when Mr. Arun Jaitley was the minister, again the situation was reviewed. And they found that the population stabilization hasn't come. Therefore, they don't want to let down the states which followed the family planning scheme. Again, they introduced another amendment, constitutional amendment, and because of this constitutional amendment, the delimitation was freezed for another 25 years. which expires in 2026. So, by this freezing of delimitation, the 1971 census is to be taken. But what one window was given is that so far as 2001 census is concerned, that can be taken for the adjustment of the constituencies. So that window was given, but however 1971 census was the basis. So what can you infer from their conduct? So therefore their conduct is very clear that there is no population stabilization, and therefore the states should not be deprived of which is adhere to the population control. So that is why this delimitation issue was taken up, and merely because Mr. Amit Shah comes here and says in a meeting that it will not affect the states, that impending danger in 2026 will be taken away. Because what we could see from the constitution, if you see Article 81 and Article 82, the kick-in date for the delimitation starts in the year 2026. So it says that when the census is taken after 2026, then delimitation shall be mandatorily done on the basis of the census that is taken after 2026. So now visualize a situation where the census has not been taken since 2021 because of the COVID. 2026 the census is completed, taken. Now we will have the delimitation mandatorily from 2026 onwards. Can you prevent it? You can't say orally somewhere in the streets or somewhere in the meeting. You have to you have to go to the parliament and make a statement, and it has to be recorded.
You also
And
mentioned
the operation of the constitution has to be stopped. So unless you bring in a constitutional amendment, you can't simply say and walk away. What happened to Jammu and Kashmir? One fine day, a state, Jammu and Kashmir, which is the largest state, was broken into three. A state, by introduction of one bill and Article 370, amendment of Article 370, they broke Jammu and Kashmir into two union territories and one state, and the state itself was not brought into effect till the Supreme Court came down heavily and said that look, you have to do it. And only recently they conducted election. So, and what happened to the Delhi NCT? It is now reduced to that of a municipality. So you can't sleep over your rights. And rightly our Chief Minister has taken up this issue, called for a meeting, called all the Chief Ministers. At this juncture, I want to tell you one thing. There is a population commission established by the Prime Minister, and the main agenda of the population commission is how to bring in population stabilization, because once they fall back on the population stabilization, which is a criteria to arrest or to bring a balance between all the states, they formed a commission in which the Prime Minister is the chairman, and the states, nearly 8 states are members of that population commission. In that population commission, committee, union ministers are also there. The states who are going to be affected, including Tamil Nadu, are also members in that population commission committee. It's a population commission committee, and apart from the states which are going to be affected, states which are going to be benefited is also there. What happened to that commission? Till today, that commission has become dysfunctional. So you are not, making that commission functional. The commission has to function, then only a report can be filed, a report can be accepted, and then you can proceed further. You are not making constitutional amendment, but the impending danger is the census has to be taken in 2026. So therefore, how can you say that there is no cause of action for the Honorable Chief Minister to even speak about this? We have all the materials that is staggering at our face, and rightly our Chief Minister has taken up this issue.
So our Joint Action Committee also proposed a solution that another 25 years of population
Correct.
census freeze. But will it help growth of the country? Will it help other states to grow, like their representation? What about their representation?
Now, what has happened from 1971 onwards? Is our country not growing?
Obviously, growing.
So, therefore, that is the answer. You brought the freezing from 1971 onwards. How many years have gone? You tell me, please tell me. 1971, 81, 91, 2001, 2021, nearly more than 40 years. So, therefore, nothing is going to be affected.
But you can see UP and Bihar, they are still undergrowth states, but with more population, like 25 crore and 12 crore.
They can have the population, they can have their representative, but you can't have the number of constituencies according to the population. Then there will be a mismatch. It will run against the assurances given by the union government to the other states like Tamil Nadu. Imagine you have more number of MPs. Now what will happen to power bargaining? The South will be totally neglected. You don't require any MPs to form a government at all in at the union level. Imagine you have more number of MPs, more number of constituencies in a state like Uttar Pradesh. What will happen according to the population? What will happen? All your money, tax-paid money that is taken from the Tamil Nadu will go and be dumped in the states like UP. We are not against the tax sharing, but our rights will be reduced to nothing. You will not have a political bargaining power at all. Our political participation in the formation of the government will become meaningless. So therefore, that is why the Chief Minister has taken up this issue rightly at appropriate time.
So one more question about this. At this point, do you think this is the long-term plan of BJP to reduce the voice of South?
I think so. That is why our Chief Minister is cautioning all the southern states. Let us not. Let us be aware. Let us be awake of the situation. Let us not sleep over our rights. And at every level, the BJP is trying to turn this country into that presidential form of government. You see the type of laws they are bringing, all marching towards the presidential form of government. They say one nation, one election, uniform civil code, and they see the intrusion into the minority rights. The classical example is the new amendment laws made in the Waqf. Ultimately, it is reduced nothing. Now, a Muslim to donate a property to the Waqf also, you need to, prove that you are a Muslim. Does the property have a character of any religion? If a Hindu wants to donate it to a Waqf, he can't do it. A Muslim wants to donate his, a Christian wants to donate his property to a Waqf, he can't do it. So therefore, where are we heading to? So it's time that the parties in all over the states, political parties, should also think about the rights of the people. Ultimately, we can't mortgage the rights of the states like Tamil Nadu, which is always fighting for its own right, not only for its own right, for the rights of other citizens of this country.
That was my next question, sir. So you talk about that UCC and One Nation One Election bills and undermining federal structure, constitution, and everything. So what will be the action plan of DMK to fight all this? Because the DMK, the one party which strongly fight against BJP in this political arena. So what will be, unlike the delimitation, Will DMK form committees comprising all over Indian leaders for fight against all these laws and issues?
I think this answer has to be answered by my honorable leader. I can't take any decision on it. But the way you can see that issues have been taken up and fought for all the rights to be preserved of the state, you can be assured that for every issues the party stand is very clear. The rights of the people have to be protected. The state's autonomy has to be protected. The state's federalism, cooperative federalism has to be protected. And whatever the rights that is given to us under the constitution, be it legislative powers, be it other powers of the state, so that always the DMK strives hard to fight for it as well as to protect and preserve it.
Okay, sir. My last question. So, if education in the concurrent list is the only problem if we cannot abolish NEET, so will the DMK move to SC to shift the education to state list?
I think our one of the member of Legislative Assembly, Dr. Erilan, has filed a writ petition challenging that removal from the state list. I myself, as a private member bill, introduced a private member bill as an MP. I introduced a private member bill in the Rajya Sabha to shift from the list 3 to list 2. The education and all its subsidiary things associated to education. The reason is that when we established universities and we have the infrastructure and the cost is borne by the state, why should the union poke its nose in the selection committee of a selection of vice chancellor? So therefore, right time, including the NEET. Why should the NEET exam be there when we have a power to conduct board exams and the admission is done by the state? So therefore, we have done at every level. And at this juncture, moving Supreme Court, so far as the NEET is concerned, already challenging the Section 14 of the National Medical Commission. The suit has been filed in the Supreme Court by the state government. And yesterday also, the all-party meeting, they have taken a decision as far as the president's the rejection towards the NEET exemption bill to approach the Supreme Court.
It was a very insightful discussion, sir. Thanks for your time and discussion and deep thoughts. Thank you.
Thank you.